when they are conducting their affairs, when they are out of the law or within the law. And for emphasis, Mr. Chairman, again in the case of retired Captain Makindye and others versus the Attorney General, Consumer Petition 44 of 2015, the court addressed itself. I will just refer to a short quotation so that I can emphasize. Citing an American case, Colenda versus Lawson, the court was of the view that, as generally stated, the void for vagueness doctrine requires that a penal statute defines the criminal offense with sufficient definiteness that an ordinary person can understand what conduct is prohibited and not prohibited, and in a manner that does not encourage arbitrary or discriminatory enforcement. The rationale, Mr. Chairman, and members of the panel, is that I should know whether to cross the road or not to cross the road is an offense. That was an example. But also, it is intended for an ordinary man. Mr. Chairman, in society we have individuals who are high up there. We have individuals who are in the middle, we ordinarily refer to as reasonable. They are not far off. And then we have the others who are lower, who in different aspects are referred to as the riffraff of society. The requirement for a law to be certain lowers itself to the lowest in society. The law should be very clear that an ordinary person, the lowest in society, is very sure about how they are going to conduct themselves. And that was the submission that offense which says to do anything or not to do anything that constitutes or compromises the security of the defense forces means that I am effectively at a cross junction. I don't know whether to go left, right, north, south, east, or west. The other one, the third question my colleague raised was in regard to the court being impartial. Mr. Chairman, the courts have recognized that military courts, like the one we are in, is intended to charge or to try officers for disciplinary matters. And of course, in our UPDF Act, there is a clause which brings in the civilians. But again, Mr. Chairman, the courts have made a pronouncement about the character of the military court, it being appointed by the executive, and therefore the officers forming the courts being subject to the executive. And the courts have made it clear in the case of the Second Lieutenant Ambrose One versus Uganda. It says that courts which have to try any civil or criminal matter must be independent. It's a command. Under Article 28(1), and the courts have said by virtue of the appointment of the military court is not independent. Mr. Chairman, we are not making or referring to the individuals because who are before us, or before whom we are standing, because we know that theirs is an appointment and they are executing the lawful mandate of their appointing authority. So it's not character of individuals, it is the institution, Mr. Chairman. Because I said military courts are not independent and that they are military courts of the executive, they belong to the executive. Moreover, the charges they try are brought by the army. And Mr. Chairman, the courts made reference to two sets of people Those who are not subject to military law, I suppose like me, and those who are subject to military law, I reckon, Mr. Chairman, like yourself, Mr. Chairman, and the officer before us, because they are soldiers serving, doing a national duty of protecting our country. But he said that persons who are subject to military law, like every other person in this country, enjoy fundamental rights which may only be limited in the manner allowed by the Constitution. He said that judges of independent courts cannot be under the administrative control of the authority that brings the charges. In this case, my Lord, Mr. Chairman, rather, to the extent that the court is of the institution of the UPDF, and the offense that has come, one of which is to compromise the security of the UPDF. Again, it shows that the institution which placed all these gallant officers in their offices, the executive, is complaining before them. Put simply, because, Mr. Chairman, I'm a parent, I have a grown-up child, and I am offended by my neighbor, Mr. Kalibala, and I constitute a panel of my children to try the matter where Mr. Kalibala is accused, and I am the complainant. The likelihood that my children will find against me when I buy their clothes, uniform, when I pay their salaries, is unlikely. But more importantly, in the eyes of Mr. Kalibala, he's not likely to see that as a fair process. Because after all, the person charging him is one who I can direct to attend to me by instruction. And they must attend to me whether they want it or not. Because as officers, you answer to the high office. Mr. Chairman, in that respect, the courts have taken note of individuals who are subject to this law and said that officers and militants of the Uganda People's Defense Forces do not, by joining the UPDF, surrender their rights and freedoms on account of joining the UPDF. We are thankful that today we have name tags. If I turn around, I can see Mr. Walimbwa. He doesn't surrender his rights because he has joined national service in terms of the UPDF. He enjoys the same rights as I enjoy. So if in one dispensation, I am entitled to a fair and biased court, we are the same, all of us taking the same image, and therefore he is entitled to the rights and glory. So the courts have said that such rights and freedoms are available to the officers and the militants of the UPDF because they are available to all the other Ugandans who live in this country because they are inherited. The other point, Mr. Chair, my colleague referred to Article 137, 5B of the Constitution. He alluded to a question which the court comes across, and a question which is a request by the party. To be certain, Mr. Chairman, in this case, it is the accused persons.
Man, already na bargaining nga kuolwo nga noli yali amanyi agitwala kuolwo kitegeera nga lwaki twatuukana kweyo price kati simanyi atwale nakuddamu ate nakola kikumubuuza kozesa bargaining nga bagitwala kuolwo. So now I need again to confirm era kamale n'okuconfirm but sente zirina kuba kyasobola kukiba.
It does not allow this court the opportunity to determine whether there is sense in raising that question, because that is not its duty. To determine, upon response from our colleagues, that we can examine the validity of that question, or if in their view, the question has been had before, is to defeat the Constitution. Mr. Chairman, Article 3 of our Constitution says that anyone who acts in breach of the Constitution creates a very big offense, which perhaps, again referring to Mr. Walibwa here, will now bring him under this court. It is treason. So, we are urging the court, Mr. Chairman, that once we raise the questions that we have done, the honor or the duty of this court is to put the question in proper wording and send them out, and not to determine whether the questions should be sent, because the duty it has been done already. There has been a request. Mr. Kalibala also referred to the Enforcement Act of Human Rights and said derogating from a non-derogable right, Mr. Chairman, is an offense. That should be Section 11, and that is true. As officers of court, Mr. Chairman, we do have a duty, perhaps akin that of the judge advocate, to advise the court. It is a duty we ought court as officers of court. What Mr. Kalibala did not say, Mr. Chairman, is that while people executing office have got immunity of office, this particular act waives that immunity. So, the judge advocate, if it becomes aware that this court is deviating from it's not part of the court. If any of us became aware that we are deviating from a non-derogable right, we are committing an offense. And that offense is alive for between 10 to 15 years. Moreover, the defense that I was acting under instruction does not arise. Mr. Chairman, in 15 years, I will be nearing 65. So I wouldn't want my younger colleague here to keep it in his heart and after 14 years come against any of the distinguished officers there to say on the 14th of May, he took the view that they were derogating from a non-derogable right. Because the defense of saying we are executing our mandate of officers established under an act of law will not be available to distinguished members. That is the command of the law. Our request, Mr. Chairman, seeing that my colleague referred to the attributes of a force which is patriotic, which is disciplined, and a disciplined individual or institution agrees with established rules and principles, and given that the same command the force to subject itself to civilian authority, we do request that as commanded by Article 137(5)(b), which directs the court to submit the question, and when my colleagues have raised the questions, we do not engage the chairman, and most politely, with questions as to whether we should refer, rather, we spend the other part of the day by getting the right language of the questions, which shall then be referred to the Constitutional Court to interpret as they are mandated to do under Section 1, Article. Mr. Chairman, again, and for my colleagues from the state, led by the prosecutor, we just want to refer you, when I say my God, it's not derogatory, the court, to Section 195 of the General Court Martial, which spells very clearly and succinctly the functions of the General Court Martial. My Lord, Mr. Chairman, that section has 3 subsections, and the first subsection has got 5 paragraphs, none of which can't give this court power to interpret provisions of the Constitution or of any other law. Therefore, I request that you surrender to even a process to replace this court and the questions be crafted with the aid of our colleagues, ourselves, and sent to the higher court for the next interpretation, so that if we are to return here following the finding of that court, we are sure that all the doubt we had about jurisdiction, about impartiality, about extraterritorial effect, which are now the pending points, are handled and that we can proceed peacefully and in a manner that is subject and under established law. That is my request. I thank you, Mr. Chairman, members of the panel, for this opportunity.
Thank you, Mr. Chairman and honorable members. The 4 issues framed by my learned friend here are well canvassed by my colleagues here. Permit me, Mr. Chairman, to add on to those 3 issues. But before I do so, Mr. Chairman, just 1 to 3 minutes to reinforce the 2 issues, the first 2 issues on Council Kalibara raised with authorities on the arguments have been adequately canvassed, and we are convinced this honorable court is persuaded by those submissions. Now, with authorities on vagueness of section 128, that is issue number 1. Vagueness, the uncertainty of that particular provision. The Constitutional Court has had occasion to pronounce itself on that particular matter in the case of Andrew Karamachi. I'll furnish you the copy with you. Rather, I'll furnish you the copy. Andrew Karamachi, Robert Shaka versus Byesigye. It's Constitutional Petition number 5 of 2016. Can you get the copy? But the point emphasized here, Mr. Chairman, the doctrine of evidence in the legislation. This is what they said on page 10. This is the Constitutional Court. The doctrine of vagueness is founded on rule of law. The doctrine of vagueness is founded on the rule of law, particularly on the principles of fair notice to citizens and the limitation of enforcement discretion. Fair notice to the citizen comprises a form aspect, an acquaintance with actual text of a statute, and a substantive aspect, an understanding that certain conduct is subject to legal restrictions. The crux of the concern for limitation of enforcement is that the law must not be so devoid of precision in its content that a conviction will automatically flow from the decision to prosecute. The threshold for finding a law vague is relatively high, and this is what they set as a standard. The factors to be considered in determining whether the law is vague or not: A, the need for flexibility and the interpretative role of the courts, that is number 1. 2, the impossibility of achieving absolute certainty. A standard of intelligibility being more appropriate. That standard of intelligibility is critical and crucial. 3, the possibility that many varying judicial interpretations of a given disposition may exist and perhaps coexist. They cited the case of Nova Scotia Pharmaceutical. It is a 1993 decision which you find here. So the doctrine of vagueness can be summed up in one proposition. This is how they summed it up, the Constitutional Court. A law will be found unconstitutionally vague if it lacks in precision as not to give sufficient guidance for legal debate. That is, for reaching a conclusion as to its meaning by reasoned analysis applying legal theory. The term legal debate is not used. The term legal debate is not used to express a new standard or one departing from that previously outlined by this court. It is rather intended to reflect and encompass the same standard and criteria of fair notice and limitation of enforcement discretion viewed in the fuller context of analysis and the quality and limits of human knowledge and understanding in the operation of the law. The criterion of absence of legal debate, and so it continues and continues. And finally, Mr. Chairman, this is the decision they arrived at after analyzing all that. A statute is also void for vagueness if the legislature's delegation of authority to judges or administrators, like this general court martial, is so extensive that it would lead to arbitrary prosecution. I need to emphasize this. A statute is also void for vagueness if a legislature's delegation of authority to judges or administrators is so extensive that it would lead to arbitrary prosecution. Vague laws involve three basic dangers, and this is what we want to caution against. This is what they stated. Vague laws involve three basic dangers. One, they may harm the innocent by failing to warn of the offense. Ignorance of law is not defense, yet the law itself is vague. Two, they encourage arbitrary and discriminatory enforcement because vague laws delegate enforcement and statutory interpretation to individual government officials. Laws are usually found void for vagueness if after setting some requirement or punishment, the law does not specify what is required or what conduct is punishable. Also, an enactment is void for vagueness if its prohibitions are not clearly defined. Finally, Article 28(12) is very clear. It requires that an offense must be defined. That definition, in my view, must be clear enough to enable citizens to distinguish between the prohibited conduct and the permissible one. Any vague interpretation will lead to satisfy the requirement of Article 28. In fact, the case of Charles Onyango versus Yakuneke. So this is authority by the Constitutional Court, which has got that primary obligation of interpreting the Constitution. It's binding on this one. And it's very instructive in that when you look at Section 128, it opens floodgates. It cuts the net wide offenses relating to security. And punishment, this is how serious it is. So a vague law to subject somebody to a death penalty is something that cannot be sanctioned by the existing constitutional order. And the reason we are asking, we need interpretation of the constitutional court about that particular provision. So that is the authority in regard to the vagueness of Section 128 relating to offenses compromising security. The other issue, the second issue, again, I would cite the authority, the issue relating to subjecting civilians to martial law, which my learned friend here adequately canvassed. But the authority, and we cited a number of authorities. Cited the ones of Uganda Law Society, cited Amoni Yagaba, and cited Kawasbrook and a couple of others. But the point I wanted to emphasize, there are two authorities that have come subsequent to the decision of Kawasbrook. One of Amoni Yagaba, which is 2022, and it was very, very clear. And on that one, there was nothing. The one of Yagaba. Yes, the Attorney General preferred an appeal against the decision in the Karasburuka matter. But the one of Harmony, there is no pending that. There is no any order of state and no any other fact order in that regard. My learned friend alluded to the fact that the other side may raise a contention that there was an order of stay in the Karasburuka case. That has also been subsequently handled by the Constitutional Court, which took a decision in that case. They have decided, one, in the case of Harmony, but more sufficiently in the case of Semju Abdul versus the Attorney General, Constitutional Petition number 4 of 2018. The most recent one, it is, to be exact, it is the 3rd of February 2023. It is as fresh as these charges before you. This decision, the leading judge, may his soul, Justice Kakulu, may his soul rest in eternal peace, had the occasion to reproduce verbatim the decision in the Karasburuka case. Sum them up. And he said, the constitutionality, no, I have carefully listened and considered the submissions of both counsel on the constitutionality of sections 2:119 and 197 of the UPDF Act. I have also carefully perused the affidavits and so on and so forth. The constitutionality of the issues raised above were substantially raised and settled in the recent constitutional decision of Honorable Michael Karasburuka versus the Attorney General. That is constitutional petition number 45 of 2016. Then he said, I will produce the declarations in extension for clarity. He highlighted them. I will not take your time, but they are very few. Yes? Yeah, just number 5. No. The General Court Martial established under section yes. No, number 2, the General Court Martial's jurisdiction is only limited to trial service offenses under the UPDF Act. Then he said, 3, military law under the UPDF Act must be construed to exclude laws that are the preserve of the civil courts of judicature. I will come to that later when I'm raising another issue. But more specifically, number 4, persons subject to military law. No. 5. Sections 119(1)(h), subsection 1 of section 179 of the UPDF Act are unconstitutional as they are inconsistent with Article 28 of the Constitution. That is a finding which is well captured in the decision of Karasburuka and reproduced in a number of those decisions. And they had occasion to make this finding after listening to the submissions of the state that in the Karasburuka matter there is an appeal, there is an order of state. This is what the Constitutional Court said after listening to the submissions, which are likely to come from the other side when they are replied. This is the response and the finding of the Constitutional Court. The above authority is good law, and I am bound to follow it. We are well aware that the above cited decision is currently pending appeal at Supreme Court. Until the Supreme Court decides otherwise, the authority is still good law. The fact that gave rise to this petition are almost on all fours with those in Honorable Karasburuka's case. Applying the above authority, I find that the petition is on all fours. The petition is therefore allowed on that account alone. The same declarations and orders in the Karasburuka petition apply to this petition. This is as of recent as 2023. So, this court, I'm afraid to say, its hands are now tied. Has no choice but to go by the declarations of the Karasburuka decision and reinforced in the decision of Semju and Yagaba and others which have come subsequent to the one of the submission I will make here. Again, in emphasizing the point Fred Mpangayi has raised of Article 3. Any attempt by this General Court Martial to proceed with the prosecution in total disregard of this finding of the Constitutional Court, with all due respect to the General Court Martial, it will be treason. It will amount to treason for this General Court Martial to proceed with the prosecution, with the hearing of the matter, in total disregard of this, because the Constitution Article is very, very clear on the observance of the constitutional order, respect to the given constitutional order and interpretations given. So I urge you, Mr. Chairman, members of the panel, not to commit treason by proceeding in this matter. Now, Mr. Chairman, with your permission, I beg to move and frame to 3 issues. The first issue, in addition to the ones, the first one is about the propriety of the proceedings, the charge sheet canvassing Mr. Chairman. Mr. Chairman, whether the trial premised on arrest and rendition of accused persons from Kenya in total disregard of the extradition law and other international laws, and on the basis of a memorandum of understanding which is not within the framework of the extradition laws, amounts to a violation of Article 28 of the Constitution. Mr. Chairman, in your finding this morning, you indicated that there is an MOU between the government of Uganda and Kenya to exchange people presumed to have committed offenses, which obviously is not premised on international law or the existing extradition acts or laws of both countries. So that is a matter which requires constitutional interpretation. Can there exist an extradition treaty outside? No, not a treaty, an MOU, yet the law provides for an extradition treaty. And is it that a violation of Article 28 of the Constitution, which guarantees the right to fair hearing and other relevant provisions? So I don't need to labor so much because we had out that point earlier on. I would like to adopt the submissions we made earlier on about rendition in violation of the extradition law. So we like that issue matter also to be referred to the Constitutional Court. The other issue, Mr. Chairman, is the jurisdiction of this honorable court to deal with cases under the Firearms Act. Mr. Chairman, in this Karasuka case, which is again reproduced in the subsequent decisions which I've just made reference to, particularly the one you sent. So, clause 4, paragraph 4 of the decision. Paragraph 3. Military law under the UPDF Act must be construed to exclude the laws that are the preserve of civil courts of judicature established under Chapter 8 of the Constitution. And Mr. Chairman, this was a reinforcement of the decision in the case of Dr. Kiza, Byesigye, the very person before you here, in Constitutional Petition number 12 of 2006, where it was adequately, again, handled by the Constitutional Court, that the offense is not the one whose particulars appear in the charge sheet. The offense in the charge sheet is under Section 3, by then it was Section 3, now Section 4 of the Firearms Act. That offense does not fall under Section 193. I'm sorry, it may not be that clear, the photocopy was not clear, Mr. Chairman. That offense, Section 3(1) of the Firearms Act, which is now Section 4 of the Firearms Act, and it encompasses counts 3, 4, and 5. That offense does not fall under Section 119 of the UPDF Act. The offense of unlawful possession of firearms ordinarily the monopoly of the UPDF forces. They said this offense is neither defined by any law in our statute books, nor has the sentence for it been prescribed. The said amendment of the charge, there was an amendment to the charge sheet, is clearly not helpful. They went ahead to say that government or UPDF attempted to come up with instrument number 13 of 2006, ostensibly I think to address that lacuna. Uganda People's Defense Forces, arms, ammunition, and firearms, to define that phrase, monopoly of the defense forces. The court said that instrument was also redundant. And the beauty with this, my land friend here was still the judge advocate, was involved in this matter and is fully aware of the facts in this particular matter and all the attempts that were made to address those legal challenges. In other words, their finding was that you cannot widen the scope of Section 119 to bring into operation the provisions of the Firearms Act or any other law, including the Suppression of Terrorism Act, which is a preserve of the civil courts. That would be overstepping the mandate of the General Court Martial. I can say incarnation of the same here in this very charge sheet. So what ordinarily ought to have been done is to define that animal, which clearly the animal code offenses which are ordinarily a monopoly, no, weapons rather, weapons which are ordinarily a monopoly of the UPDF. Up to now, ever since this decision was made, the Byesigye decision, this animal is still anonymous, undefined. And the attempt to do so in this instance were also declared futile. So, Mr. Chairman, unless and until that phrase is unpacked and clearly dissected and explained, this General Court Martial cannot try offences under the Firearms Act. So, we would like that issue again to be also canvassed by the Constitutional Court. Finally, the issue I would raise is whether the arrest, conviction, and the detention of Counsel Kiza, one of the defense lawyers, amounts to violation of Article 28(3) of the Constitution. Mr. Chairman, Kiza is on record up to the present moment is one of the defense lawyers. And I'm glad when we raised it here and said, how do we cause the appearance of Kiza to execute his